Hello everybody, welcome to jurycentral.com online classes for law exams. So today I will be discussing with you the solved previous year question paper of BHU LLM 2018, and this paper is related to 1 year LLM as well as HRD, the Human Rights Specialization Course 1. So before starting this session, like always, I would request all of you to kindly like, share and subscribe to the channel if you haven't done yet. So without wasting any further time, let us start our first question. And also those of you who have missed the previous year question paper of 2019, I have already done a detailed video on that. So kindly check out the I button which is visible on my image. You would find the video. I have already created a separate playlist where you would find the missed videos of BHU LLM. So let us start. So this is the question paper. This is a main question paper, and this has been done in offline mode, and I have downloaded the question paper from their official website BHU. So if you want to download, you can download, and the answers are suggestive in nature as it is based on my personal research. In case if you feel that I have committed any mistake, do comment in the comment section below. Question number 1, the Hindu marriage 1955 is not applicable to, and also one more thing, the total number of questions are 120. So we would be dealing a total number of 120 questions. Question number 1, the Hindu Marriage Act 1955 isn't applicable to. This is option number 4, members of scheduled tribe. Question number 2, while waiving of the cooling off period for divorce on mutual consent, the Supreme Court of India in Amardeep Singh versus Harveen Court 2017 referred to article. This is the option number 2, article 142 of the Constitution of India. So for giving effect any decree or order, this is the exceptional power of the Supreme Court. Question number 3, a 45 years old Hindu male wants to adopt a girl as his daughter. Which of the following girl may he adopt? This is option number for 12 years. So why I am not choosing 18 years? Because under Hindu Adoption and Maintenance Act it is given like a person which is who is above the age of 15 years cannot be adopted. So the correct option is option number 4, 12 years. Question number 4, an aggrieved party may file a petition for the restitution of conjugal right before this is option number 3, district court. Question number 5, A and B are adult Hindu male and female. B is a daughter of A, maternal aunt. A and B marry each other. Such a marriage is, so in this case, such a marriage is void but not punishable. Question number 6, where the dependent has a right to receive maintenance out of an estate and such estate is transferred, the effect of such transfer is this option number 4, right of dependent on to receive maintenance exists only when the transfer was gratuitous and the transferee had notice of such right. Question number 7, who cannot ask for partition in a Mitakshara Hindu joint family? This is option number 2, legitimate son. Question number 8, who amongst the following is not class 1 heir according to the Hindu Succession Act 1956? This is option number 1, stepson. Question number 9, when two persons are related by blood or adoption not wholly through males, they are called cognate, and in case if they are wholly related by blood or adoption through males, they are known as agnates. Question number 10, a Hindu widow inherited property from her mother. Widow dies intestate and issueless. She left behind her one sister and parents of her husband and husband's brother son. Her property will devolve. So in this case her property will devolve on a sister, because it is given under Hindu Succession Act that if a woman has inherited from her father's side and in case if she dies issueless, the property will devolve upon the heirs of her father. Question number 11, Gloucester Grammar School case is related with. This option number 1, damnum sine injuria. Damnum sine injuria means there is a physical wrong but there is an absence of legal wrong and it is actually not enforceable. Question number 12, innuendo. Innuendo is prima facie innocent. 13, tort of conversion is committed against. This option number 1, chattel. Question number 14. Maxim qui facit per alia facit per se is applicable to fix applicability on. This is option number 4, master. Question number 15. Word noir is, so the word noir is actually option number 3, French. This is a French word. 16. Maxim omnio reti habitio retrora habitur et mandato priori occuperator refers to. It refers to ratification of an act, relates back an equivalent of previous request. That means ratification has a retrospective effect. Question number 17. Misfeasance term is used for this. Option number 1, improper performance of lawful act. Question number 20. Statutory authority provides protection to defendant. So it provides protection to defendant against. Option number 3 for act and all inevitable consequences of act authorized by statute. 21. Distinctive feature of act of God is this. Option number 2, damage is caused without human intervention. Question number 22. In rescue cases, doctrine of assumption of risk, so it doesn't apply in rescue cases. 28. This is question number 18. There must be some typo error. Okay, so the question number 18 is actually shifted to this page. Peninsular Steam Navigation Company versus Secretary of State for India is related with, so this case is related with option number 2, sovereign immunity. Question number 19. A minor can sue for prenatal injuries in accordance with maxim. This is option number 1. The maxim is nasciturus pro jam nato habituor. Question number 23. When there is lending a machine with servant to another person for determination of vicarious liability, so then there is a presumption that employer from whom work is to be performed becomes master. For 24, hire and fire test is applied to determine this. Option number 3, relationship of persons to pay damages. Question number 25. In case of Maring versus Graham Aviation Company Limited, court decided that for tort of false imprisonment, so for tort of false imprisonment, this option number 4, knowledge to plaintiff regarding deprivation of liberty isn't necessary. Question number 26. The subjective theory of recklessness revived in the case of, so it was actually revived in the case of option number 2, Cunningham. Question number 27. The term dishonestly in section 24 of the Indian Penal Code means doing anything with the intention of option number 2, causing wrongful loss or wrongful gain. Question number 28. Which of the following is not included in the definition of movable property in section 22 of the Indian Penal Code? This is option number A, B and C. Things attached to earth, things permanently fastened to anything which is attached to the earth and land. So this it is not included in the definition of movable property, because movable property is something that can be moved, but these properties cannot be removed. Question number 29. A was having a costly wristwatch. Out of fear, A did not resist while B was removing that wristwatch. Which offence has B committed? So B has committed the offence of extortion. If he didn't had resist out of fear of instant death, then it would have become robbery. Question number 30. In which of the following offence the delivery of property is not an essential element? This is option number 4, mischief. Question number 31. The House of Lords found the accused guilty of an impossible attempt by applying the criminal attempt case in the case of, this is option number 2, R versus Shivpuri. 32. While distinguish preparation from attempt to commit crime, the Supreme Court of India applied proximity theory in the case of, so proximity theory is applied in the case of state of Maharashtra versus Muhammad Yaqub, option number 2. Question number 33. X, a boy aged about 22 years and Y, a girl aged about 20 years of different caste and wanted to marry each other. They approached a priest of Arya Samaj temple and requested him to perform their marriage. The priest demanded rupees 25,000 for performing the marriage ceremony, otherwise he will not perform it. X and Y paid the amount and ceremony was performed accordingly. The priest committed the offence of no offence because he actually charged his fees. Question number 24. A, while travelling in a bus, tears the seat cover when the bus conductor demanded for bus fare. A is guilty of this. Option number 2, mischief. Question number 35. In which of the following cases the accused cannot successfully take the defense of de minimis non curat lex? This is option number 2, where the accused while boarding into railway compartment causes hurt by pressing toes of another. Question number this is question number 35. This question number 36. Actually the question paper are not properly scanned, so this is the reason why the language of the questions you would find a bit illegible. 36A, making an unusual sound, suddenly jumps in front of a woman in dark night. The woman out of fear became unconscious for 2 minutes. Which of the offence A committed? The correct option is option number 2, this is assault. Question number 57. This is 37. Which of the following statement is not correct? This is option number 4. The right of private defense is available against assault. Question number 38. Who has defined crime as a legal wrong followed by a criminal procedure which may result in punishment? This is option number 4. Glanville Williams. Question number 39. Which one of the following is incorrect in explaining actus reus? This is option number 2. Certain circumstances specified by law. 40. In which case the Supreme Court denies to curtail the ambit and scope of section 498A of the Indian Penal Code? This is actually option number 3, Rajesh Kumar versus State of UP. 41. Yusuf Abdul Aziz versus State of Maharashtra case is related with this option number 3, constitutionality of section 497, which means adultery. Question number 42. A proposal when accepted becomes a promise, option number 1. 43. Communication of acceptance is complete as against the acceptor, option number 2, when it comes to the knowledge of the proposer. Question number 44. A man enfeebled by disease is induced by B's influence over him as his medical attendant to agree to pay B an unreasonable sum for his professional services. B employs. This is option number 4, undue influence. Question number 45. Which of the following case is related to fraud? This is option number 4, dairy versus pig. Question number 46. Khan Bull versus Lakha Khan is related to which of the following? It is related to option number 2, capacity of parties. Question number 47. A, being entitled to an estate for the life of B, agrees to sell it to C. B was dead at the time of the agreement, but both parties were ignorant of such fact. The agreement is, so in this case, the agreement is actually void. 48. A trader supplied to a miner wheat and rice required for food. On the failure of the miner to pay for it, the trader files a suit. The trader will get relief under section 68 of the Indian Contract Act. Question number 49. A agrees to sell a horse worth rupees 5,000 for rupees 1,000 to B. A's consent to the agreement was freely given. The agreement is a contract. So in this case, the agreement is contract because the consent is actually freely given. 50. A promises to pay a time-barred debt. Such an agreement is enforceable under the following sections of the Indian Contract Act. So this is actually enforceable under section 3, that means section 25, option number 3. 51. A promises to be to drop prosecution which he has instituted against B for robbery, and B promises to restore the value of the things taken. The agreement is, so in this case, the agreement is option number 2, void, as its object is unlawful. Question number 52. Agreement by which any person is partially restrained from exercising a lawful profession, trade or business of any kind is, this option number 2, to that extent void. Question number 53. A proposes by a letter sent by post to sell his house to B. B accepts the proposal by a letter sent by post B. So can he revoke? So in this case, may revoke his acceptance at any time before the letter communicating it reaches A. 54. A wagering agreement is, it is actually void but not unlawful. Question number 55. A contracts to pay B rupees 50,000 if B's house is burnt. This is a option number 2, contingent contract. 56. A contract of pledge is a contract of, it's a contract of bailment, option number 3. 57. Which statement is wrong regarding agency under the Indian law of contract? It is option number 3, consideration is necessary to create an agency. Actually, consideration is not necessary to create an agency. 58. When the whole of the meher will be paid at the time of nikah, it is said to be meher-e-muzzal, and if it is deferred, then it is known as option number 1 meher-e-muazzal. But in this case, the correct option is option number 2 meher-e-muzzal. Question number 59. A Muslim husband who is mature and of sound mind swears not to cohabit with his wife for not less than 4 months. Such a mode of talaq is known as option number 3 ila. Question number 60. A hiba can lawfully be made in favor of all of the above, option number 4 non-Muslims, mentally handicapped, as well as option number 3 women. So question number 61, I am reading it to you, but I haven't given you the correct option because I have certain confusions to the as to the right answer. So if you have the answer, if you know the answer, then kindly comment in the comment section below. Let me read it for you. 61. A is survived by her mother, a daughter and a brother. They will get respectively 1/6, 3/6 and 2/6 by the Hanafi law. How much they will get under Ishna Ashari law? So you have to comment. Ishna Ashari law is a law related to Shias. Question number 62. Under Muslim Women Protection of Rights and Divorce Act 1986, divorced woman means, so it means option both 1 and 2, option number 3. A Muslim woman who was married according to Muslim law and has been divorced by her husband in accordance with Muslim law. 2. A Muslim woman who was married according to Muslim law and has obtained divorce from her husband in accordance with Muslim law. Question number 63. Judges of the International Court of Justice are elected by this option number 1 Security Council and the General Assembly. 64. In which of the following cases the protective principle of jurisdiction was relied by the court? This is option number 2 Joyce versus DPP. Question number 65. The International Criminal Court for the former Yugoslavia was established by the option number 2 Security Council. Question number 66. Which of the following is not expressly referred to by Article 38 Clause 1 of the Statute of the ICJ? This is option number 3 judicial decisions, because judicial decisions are the subsidiary means of law. Question number 67. In which of the following cases the court affirmed the legality of the straight baseline method in determining the territorial sea? This is option number 2 Anglo-Norwegian fisheries case. Question number 68. A member of the United Nations may be suspended from the rights and privileges of membership by the this option number 4 by General Assembly upon the recommendation of the Security Council. 69. The exclusive economic zones shall not extend to her nautical miles baseline from the territorial sea. Question number 70. Who among the following is not a positivist? This is option number 2 Samuel Pufendorf. Question number 71. International law is a part of our law and must be ascertained and administered by the courts of justice of appropriate jurisdiction. So the above observation was made in the case of option number 3 the Packet Habana case. Question number 72. Decisions of the Security Council on procedural matters shall be made by an option number 1 affirmative vote of 9 members. So on procedural matters of Security Council, the decision has to be made by affirmative vote of 9 members. Question number 73. The contiguous zone may not extend, and this may not extend contiguous zone. This is option number 3 24 nautical miles from the breadth of the territory, from the baseline of the territorial sea. Question number 74. The Stimson doctrine is related to option number 3 non-recognition of governments. 75. Theory of pacta sunt servanda is associated with, this is option number 2 Ancelotti. 76. Which of the following conventions is related to 5 freedoms of the air? This is option number 1 Paris Convention for the regulation of aerial navigation. So I haven't solved these questions because as you can see the questions are already illegible, they are not properly scanned, so I didn't understand the question and this is the reason why you do not have the answer. The next question, which of the following school is founded on the assumption that it has its roots in intuitive human conscience or human reasons? This is option number 2 historical school. According to Salmon, the subjective theory of negligence emphasizes on mental attitude with respect to conduct and consequences both. So Salmon subjective theory of negligence is based on mental attitude with respect to conduct and consequences. Question number, even also I haven't solved this question. You can see they cannot be understood. Question number 84. Law is a measuring rod of the society. This statement is of this is option number 4, Roscoe Pound. 85. Who among the following is not a legal feminist? This is option number 2, John Rawls, and all the other 3 options are legal feminists. 86. Who made distinction between moral ought and legal ought? This is option number 4, Hans Kelsen. Which of the following are exceptions to command? So this all of the above. Permissive laws, laws of imperfect obligation, declaratory laws, and repealing laws. So these are the exceptions to command. Question number the next question. Jurisprudence is a philosophical aspect of knowledge of statement jurisprudence is a philosophical aspect of knowledge of law. Statement is of, so this statement has been made by option number 3, Cicero. Question number 95. There are 2 moralities, internal and external. So who has given, and it has been suggested by the Lon Fuller, option number 3. This has been 89 and this is 90. Which of the following is not a correct statement in relation to the source of law? Custom as a source of law. So the correct option is option number 1, custom is admissible against that statute. This is not correct. Question number, then the next question, which theory, 91, which theory of legal personality is supported by Savigny and Salmon? This is known as option number 3, fiction theory. Fiction theory of legal personality has been supported by both Savigny and Salmon. The next question, who wrote an essay on, let me read the Hindi one, statutory lawlessness and suprastatutory law. So this essay has been written by Gustav Radbruch. 93. In which case Kennedy J observed, our obligation is to define the liberty of all, not to mandate our own moral code. So this observation has been made by Justice Kennedy in the case of option number 2, Lawrence versus Texas. Our obligation is to define the liberty of all, not to mandate our own moral code. So remember the sentence. 94. The National Green Tribunal Act 2010 was enacted under the following provisions of the Constitution of India. So this actually the 3, Article 253 and entry 14 of list 1. Question number 95. Recently the following issue relating to noise pollution before the High Court of Allahabad was, this is option number 3, permission for use of loudspeakers. 96. UN climate change 23, that means COP 23 was held in option number 2, Bonn. COP 23 was held in Bonn, Germany. 97. Central Empowered Committee has been constituted under, option number 2, the Environment Protection Act. Question number 98. In the non-forest area, the following is grass. This is option number 1, bamboo. So earlier bamboo was considered as a forest product, but now bamboo is actually considered as a grass. Question number 99. Wangari Maathai is credited for the following. So he was credited for Green Belt movement. 100. Which of the following is true? This option number 4, polluter pays principle is a principal liability under law of tort. This is correct. Question number 101. Which of the following state was in the news in June 2016 for culling the blue bulls? This option number 2, this is Bihar. Question number 102. Which of the following is true? This option number 3, Constitution of India has definition and interpretation clause both. 103. The following article in the Constitution of India is said to be sanctuary of human values. This is option number 2, Article 21. Question number 104. 11th schedule to the Constitution is read with, this is Article 243G. Actually 11th schedule of the Constitution deals with panchayats. 104. Aadhaar Card 2016 was passed by Parliament by the procedure under Article 109, option number 4. 109 is a procedure which is adopted to pass any money bill. So Aadhaar Act was passed as a money bill. 106. Which of the following is not a fundamental right? This is option number 1, right to vote of a citizen above 18 years. Question number 107, Maternity Benefits Act responds to the, so it actually, it is given under Article 42 Directive Principle of State Policy. 108, which of the following in a case of exercise of power by the President under Article 356 is not true? This is option number 2, President may suspend any provision of the Constitution relating to High Court. President can't do so. 109, Constitution permits making of provisions for relaxation in qualifying marks in any examination or lowering the standard of evaluation in favor of the members of the scheduled class or scheduled tribes under article. This option number 1, Article 335. 110, right to fly the national flag is a fundamental right observed by the Supreme Court in the following case. This is option number 3, V.K. Naswa versus Union of India. So this case is related to right to fly the national flag, in which it was said it's a fundamental right. Question number 111, per incuriam order is the order of the court given in ignorance. 112, Supreme Court of India has rule making power under article, option number 1, Article 145. 113, the following constitutional amendment bill needs ratification by not less than one half of the states. So the correct option is option number 2, bill relating to representation of states in parliament. So if a constitution is moved, if the constitutional amendment is moved on this subject, then it has to be ratified by not less than one half of the states. Question number 114, indestructible union of destructible units referred to type of federal state of this is option number 3, Union of India. 115, the following is the outcome of Operation Duryodhan. So Operation Duryodhan was a sting operation done by 2 journalists, and after that a cognizance was taken in the case of Raja Rampal versus the Honorable Lok Sabha. 116, A sues B for inducing C to break a contract of service made by him with A. C on leaving A's service says to A, I am leaving you because B has made me a better offer. So the statement is, this statement is option number 1, relevant fact as explanatory of C's conduct. 117, oral admission as to the contents of a document, this option number 2, relevant if the party proposing to prove them shows that he is entitled to give secondary evidence of the contents of such document. So only in those cases oral admission as to the contents of the documents are admissible. 118, the question is whether A, who is dead, was a father of B. Statement by A that B was his son, it is actual option number 2, relevant as a dying declaration under Article 32 of the Indian Evidence Act. Question number 119, A agrees to sell his white horse to B for rupees 5,000. A has 2 white horses. So evidence cannot be given to show which of them was mint. So in this case evidence cannot be given. Question number 120, A and B are jointly tried for murder of C. It is proved that A said B and I murdered C. So in this case the court may consider the effect of this confession as against B. So with this we have come to the end of the session, and we have actually concluded our session with the entire 120 questions. So in this case if you feel any doubt, kindly feel free to comment in the comment section below. The answers are suggestive in nature. You may feel that few answers are wrong, and if you have the correct answer, then obviously write in the comment section below. Don't forget to like, share and subscribe to the channel, because we are posting every day a new video relevant for your competitive exams. So if you do not want to miss, make sure you subscribe, you give a like to this video, and also share this channel among maximum number of people. So with this note, I am signing off. Have a great day.